Okay, Judge.
All right. The court will come to order on case number 641135, State of Texas versus Christopher Michael Green. This is a motion on the issue of speedy trial. The charge is assault bodily injury. The allegation is alleged to have occurred on or about July the 5th of 2019. The date of arrest, the initial date of arrest was June 2nd, 20. It was a sealed information or complaint.
Actually, Judge, the original date my client was arrested was July 6th.
July 6th,
Affirmative.
presumably 19.
No, July 6th of 2020 was the first time he was arrested.
Okay, that was all right. He was arrested on that date. The warrant issued on 6/11/20.
That's correct.
All right. He bonded out on July the 7th of 20. The court has before it the defendant. Mr. Green, are you present?
Yes, sir.
All righty. And the attorney for the defendant is Andrew Freilich. Attorney for the state is Andrew Edelman. Our court reporter is Kayleen Rivera. She's taking the record on this matter. Any preliminary matter you wish to address, Mr. Freilich, besides the motion?
No, Your Honor.
All right, it's your motion, sir.
I'd like.
Are you gonna have Mr. Green testify?
I am, Your Honor.
All right, Mr. Green, I can't see you at this point. Where are you on the screen?
I'm sorry, my computer, Your Honor, camera is not really working.
All right. Mr. Freilich, are you in a position to see Mr. Green?
No, Your Honor. I've spoken with him on the telephone. I can hear him just fine on this, so I am confident he can hear us.
Well, in my case, as the trier of the facts and the conclusions in this matter, it's important that I be able to see him for purposes of knowing that it is he who is answering and that it is he who swears and does not swear. I'm not too comfortable with doing that without his visibility.
Okay. Mr. Green, are you able to get video abilities either on your phone or on your computer?
I'm working on it right now.
Okay.
The quiet village church mouse in this case is Miss Sherrera. Good morning, Susanna.
Morning, Judge. How are you?
I am well, ma'am. You and your family, everybody okay?
Everyone's doing well, Judge. Thank you.
Good. Andrew, your family doing all right? Andrew Freilich, I'm sorry.
Yes, Judge. Everybody's pretty much quarantined here at the house. I'm in my office and Cindy's in her office down the hall. So we are here just working.
Sure have a bad situation going community-wise and nationwide.
Yeah, it's community-wise, it seems like the people are out. I went to the office yesterday to talk to Jeannie, and as I was driving down there, there are people everywhere. It does not seem like people are not. It does not seem like people are not staying home. It seems like people are out all over the place, and.
Well, they wearing masks at least.
I hope so. I didn't stop at any place. I just drove straight there and straight back, but there just seemed like
Yeah.
there were a lot of cars around. So
I
I'm
got
hoping they're wearing masks, but there's a lot of people who are out, doing stuff. So,
What we're seeing is a false sense of security among some,
I agree with that.
and then this political push to make masks part of politics, which is outrageous. But what can we
Mhm.
say?
Yep. Well, I'd put on a mask if there was anybody near me, but,
I hear you.
Are you staying safe, Judge?
Pardon me.
Are you staying safe?
I got to. I'm the only one of me that I've got.
That's a good point. But you are taking all the precautions. You're trying to stay in as much as possible, not be around people.
Absolutely.
Good.
This is I'm 75 and I've got basic medical issues, for example, diabetes, which incidentally, for those who are not well versed on what diabetes is, it means that I'm literally too sweet.
I can see that. But it does like that. You just got to take care of yourself, Judge. You're
Yeah.
there it is. Like you said, you're the only one of you got, and we need to keep you around for a while longer.
Well, thank you. Let's hope so.
Yeah.
Judge, may I ask you a question?
Absolutely.
Should we go off the record,
Sure.
even though we're on YouTube? How does that
Well,
work?
we'll stay on YouTube. We'll stay
Okay.
on, but we're for purposes of legally the record.
Yes, I think there's a distinction between the proceeding being on the record and the proceeding being open to the public.
Judge, do you want me to shut down YouTube right now?
That's not necessary.
Oh.
What do you think, Mr. Freely?
I'm fine leaving it on. I'll make sure not to say anything, hopefully potentially embarrassing about my own self. I have no objection to it staying on, but definitely being off the record. So
Mr.
does that make
Edelman?
it?
I think we should leave the proceeding live, Your Honor.
That's good. That's what we're doing.
Excellent.
I'll leave whoever might be tuned in to wonder if I'm actually on the beach or not. And obviously the answer is I am not. I am safe in my home, in my office.
I'm trying to do it on my phone. Yeah.
Right there. Right there. It says settings. Click it right there. Wait. The little round I can't see with my glasses. Go right there. Go for settings. Yeah. Right there. Alright, watch. Okay, do you see settings? There it is.
Mr. Freilich, what are you doing tomorrow morning at 9:30?
I just assumed that every day I'm going to be with you at 9:30 at this point. But I have my latest count is 1, 2, 3, 4, 5, 6 cases set tomorrow morning on different Zooms.
And then you're joining us at 1:30 with your co-counsel.
Oh, Oh yeah.
Is that tomorrow,
I
Penny?
just clicked on that one.
Yes, sir.
Yeah, yeah. I just saw that.
How about Friday?
We don't have anything else after tomorrow. We're closed, shut it down Thursday, Friday
Good.
for
I don't.
Zooms.
Yeah, I don't have any plans, Judge.
For Friday?
No, just moving.
Or what about this afternoon at 1:30? We got anything this afternoon, Patty?
No, sir, not today.
The camera.
Mr.
Um,
Freilich, are you available after at 1:30 this afternoon?
I am, Your Honor.
All right, check with Mr. Green. I'm willing to be patient. We can wait a while here, but
Mhm.
if he's got problems technologically, we can give him till 1:30 to give it another shot.
That's fine.
We'll
Mr.
check
Green,
with
any
him.
progress?
Working on the settings right now. I'm actually downloading the app on my phone.
Okay, that's probably the better. That's probably better if he downloads the app on his phone. Those are usually more.
Excuse me, Your Honor. Sorry, I thought the computer would
No
be
problem.
working better. Almost got it. Okay, it's installed, you guys. I'm about to join the meeting. Okay, I'm in the virtual waiting room. Here we go.
All right.
Sorry about the inconvenience, guys.
All right.
Hey, you may want to log out of your other one.
I already took them off.
All right, then court will come back to order on case number 641135, State of Texas versus Christopher Michael Green. This is for purposes of a motion concerning speedy trial. Present are Mr. Christopher Michael Green, his attorney, Andrew Fraley. The state is represented by Mr. Andrew Edelman, who is also present. Our court reporter, Kayleen Rivera, is taking the official record of this proceeding. This is a matter that is being broadcast through YouTube for purposes of the constitutional provision of a public proceeding, hearing, or otherwise. Okay, Mr. Green, I've got your what appears to be your right ear. Now I've got your nose up. You might pull you're using your phone, I understand. Is that correct?
You're muted. Mr. Green, you have to unmute your phone.
Hello?
All right, we hear you now.
Can you hear me?
Yes, sir. Now you might
Sorry, Mom, I'm having audio problems. Excuse me.
you might place your phone a little bit further away from you so we can see your full face, your full head. Mr. Green. Hello, Mr. Green.
I can hear you now. Hello?
All right, that's a little bit better. Mr. Green, will you raise your right hand, please? Place it close to your face where I can see your right hand. All right. Okay. In this proceeding, do you solemnly swear that the answers and information you submit will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You may put your hand down. Two things, Mr. Green. First of all, during this proceeding and at any time in the court, you always have the right to remain silent. That means you do not have to answer any questions. You don't have to make any kind of statement. And obviously, in this case, you're not going to offer any documents with your signature in it that I'm aware of. Do you understand you have those rights?
Yes, Your Honor.
Are you at this time willing to give up that right to remain silent? Of course, it'll be with the guidance of your attorney. Is that correct?
Yes, Your Honor.
All right. Furthermore, you have a right to have this proceeding in an open courtroom. It is my understanding that you and your attorney are willing to handle this matter remotely because of the COVID virus. And we're doing this by computer. It's called a remote hearing. You understand that?
Yes, Your Honor.
All right. And for the record, you are saying that you're willing to give up the right at this time in this hearing to have this proceeding in the courtroom itself in public.
Excuse me?
For the record, you're telling us that you're willing to have this hearing right now by computer instead of, in fact, in the courtroom.
Yes, Your Honor.
All right. Mr. Fraley, your motion.
All right. Your Honor, first we'd ask the court to take judicial notice of the court's file.
The court takes judicial knowledge of the contents of the court's file in this case.
Thank you, Your Honor. Second, Mr. Green, I have a couple of questions. You've just been sworn in. Could you do me a favor? Can you turn on another light and then also turn your phone maybe sideways so maybe we can get a little bit more of your face? Just so we can see. Well, okay, maybe not. Okay, that's better. Yeah, just to see you a little bit better. Okay, yes. Excellent. Can you hear me okay?
Yes,
Mr.
sir.
Green? Okay, good. Okay. Mr. Green, when did you find out that you were charged with an offense in this case?
July 9th, when I was arrested and booked downtown.
And this was 2020, correct?
Yes, sir.
Okay. Do you know the complaining witness in this case? Do you know her name? Do you know who it is?
I do.
Okay. And did you have text messages or Snapchat messages from the complaining witness, in this case, Madison Garcia?
Previously in the past, correct.
Okay. And where were those text messages or Snapchat messages contained?
On my phone, which was stolen not some time ago.
Okay. Now, because of the delay, you no longer have access to that phone. Is that correct?
Negative.
Would you agree? So, yes, that's correct. So, because of the delay in this case, whereas you would have had text messages or Snapchat messages from Madison, now you do not have those because of the delay.
No, sir.
Is there any way to recover those messages from a different phone?
Negative.
And
I need that number. I've lost that Snapchat account as well because I need my cell phone number to that phone with that Gmail, and I can get that back.
okay. So what were some of the contents of those messages?
Her apologies and the whole story of what happened that night between her and her friend, which was my ex-girlfriend,
Okay.
who got into
So you have messages from Madison about that night that this incident took place that were apologies and the story behind it that would have been helpful for your defense. Is that correct?
Yes, sir.
And because of that delay, you no longer have access to those text messages.
No, sir.
And when I say helpful, I mean would they be material to your defense? Would they be very important to your defense?
I would think so.
And and now because we don't have access to those messages, it's going to be difficult or impossible to defend you in this case. Would you agree with me?
I'm sorry, sir. You're breaking up a little bit.
Without those messages, which we would have had access to, it is making defending you to prepare a defense for this case would be difficult, if not impossible. Would you agree with me?
Yes, sir.
All right. I'll pass the witness at this time, Your Honor.
Mr. Edelman.
Good morning, Mr. Green. You were not aware of a pending accusation against you until you were arrested on July 9th of 2020. Is that correct?
Yes, sir.
Now, if I understood your testimony correctly, you carried on this conversation with the complaining witness through the application run by the organization Snapchat. Is that correct?
You have to repeat that.
Yes, sir.
Have you contacted Snapchat?
No, sir. I have a girlfriend. I really don't get on websites like that or applications.
Well, for purposes of getting copies of the text messages between you and the complaining witness, have you contacted the company that facilitated those text messages?
No, sir. I just
So-
very.
So
Did
you
you-
don't actually know that those text messages are irretrievable, do you?
Excuse me?
So you don't actually know that those text messages are irretrievable, do you?
No, sir. But that's correct. I haven't contacted Snapchat about it either.
That's the witness.
Nothing further at this time, Your Honor.
All right.
Oh, we have no further evidence to present at this time, Your Honor. Just save time for argument.
Alrighty. Any other witness, Mr. Freeling? I think you're telling me that you have no other witness and no other evidence.
That is what I was trying to tell you, Your Honor. Yes. Sorry.
Well, I think you said it, but I didn't quite snap whether I was Snapchatting or not. All right. Argument, Mr. Freeling.
Judge, we're going to stick basically to the Barker-Wingo factors in this case, presenting it. The length of this delay is over a year, which of course triggers the presumption of delay that favors heavily in favor of.
Pardon me, just a minute, Mr. Freeling. Mr. Edelman, do you have any, I'm sorry, I apologize. Do you have any testimony from anyone or any evidence you wish to offer?
No, Your Honor, the state has no witnesses
Okay.
to offer at this time.
Very good. Mr. Freeling, I'm sorry to have interrupted you, but I realized I hadn't even asked Mr. Edelman if he had something he was going to present. Go ahead, Mr.
Problem, Your
Freeling.
Honor. Four factors, Barker-Wingo. The length of the delay is over a year, which ventures into the presumptively prejudicial range. The reason for the delay in this particular case is interesting because the state decided to unseal the case well after 6 months. As a matter of fact, I had it in front of me just a moment ago, but the record in this case was unsealed. Where'd it go? Back in June 2nd of 2020. So that's a delay from July to June. That's 11-month delay simply because the state of Texas decided to unseal the case at that time. That is clearly weighs against the state in this case because of the reason for the delay. We asserted our right to a trial within 10 days of the, we asserted our right to a trial within 10 days of actually finding out that my client was arrested and I was appointed in that case. So the assertion was as soon as possible in this case, and now, most importantly, the prejudice. Because those Snapchat messages, which would have been clearly helpful to our defense, have been destroyed, it becomes not a speedy trial argument solely, but also a due process argument. Whereas we can't prepare a full defense because of the delay by the state. Because of this, the state delayed in bringing this case forward, my client has lost evidence that would have been essential and material to his defense. So his due process rights have been violated, as well as his speedy trial rights. And in that, Judge, what we're doing is we're asking for a dismissal, not as a first resort, but because of the delay, because of the reason for the delay, because we asserted our right as fast as we could, and because of that prejudice, it makes it impossible to prepare a defense for him. And that's the reason why we have no other choice but to ask for a dismissal in this case, Judge. Nothing further.
Edelman.
Defense counsel is unfortunately poorly educated on how the Sixth Amendment speedy trial right works. Quoting Cantu v. State, the right attaches once a person becomes an accused. That is, once the person is arrested or charged. Mr. Green was formally accused of this offense in June of 2020. He was arrested for the offense in July of the same year. So the delay between the offense date and when Mr. Green was formally accused is 11 months. But for purposes of the speedy trial analysis, that delay is irrelevant because the speedy trial delay only begins to run when the person has been formally accused. So the speedy trial delay analysis begins to run from the date that Mr. Green was formally accused, and that was June 3rd of 2020, which means that we have a delay of roughly 45 days. Continuing with Cantu, the Barker test is triggered by a delay that is unreasonable enough to be presumptively prejudicial. There is no set time element that triggers the analysis, but we have held that a delay of 4 months is not sufficient, while a 17-month delay is. So even if the state were to consider the amount of time between when Mr. Green was formally accused and when he was arrested to now, that still doesn't amount to enough time for the court to find a prejudicial delay. Additionally, even if the court were to find a prejudicial delay, which as a matter of law it should not, the defense has done nothing more than to show that recovering the statements made by the complainant witness that would undergird his defense is more difficult. Not that it is impossible, in part because the defense has not shown any effort to contact the company that facilitated the statements in order to recover them. The defense has not shown that it has applied for investigators or expert witnesses to assist in this recovery. So the defense has only shown that putting on its defense will be more difficult. It has not shown that it would be impossible. So for the foregoing reasons, the court should find that at this point there has been no prejudicial delay that would trigger analysis of the Barker-Wingo factors to begin with. And even if the court were to find such a prejudicial delay, the court should further find that the defense has not demonstrated a prejudice that would require a dismissal at this time.
Your motion, Mr. Frey, you wish to close?
I would, Judge. I think weighing out all four of the factors is important. I would disagree with Mr. Edelman on the length of the delay, not from the arrest, but from the date of the offense, which has now been over a year. And because of that delay, he has been prejudiced because he no longer has access to certain things. So again, it's the length of the delay, the reason for the delay, when the state decided to unseal the case and trigger an arrest for my client. If you weigh out all of those things, it clearly weighs all four of them in favor of Mr. Green. And not only that, Judge, the state has the burden of proving, has a burden of in this by showing it's not an unreasonable delay. And I think here clearly we have the prejudice, which will make it, yes, as we agree, more difficult and violate his due process rights. And I think that's the reason why a dismissal would be appropriate in this case.
All right.
Your Honor, I'd only like to add one other thing, and that's a specific citation to US v. Marion, 404 US 307 at 321. It is either
404.
I'm sorry, Your Honor.
Repeat that. 404.
404 US 307 at 321. Quoting, it is either a formal indictment or information, or else the actual restraints imposed by arrest and holding to answer a criminal charge that engage the particular protections of the speedy trial provision of the Sixth Amendment.
All right. Okay. Under these circumstances, the court will deny the motion. Mr. Freilich. Anything else, sir?
Nothing at this time, Your Honor. We just ask for the soonest possible trial date.
All righty. And are you considering, or would you discuss with the state the possibility of a non-jury trial?
We would definitely consider that, Your Honor. I would have to talk to my client briefly about it, but it would be certainly something I would definitely consider. Just
All right. I will direct y'all to discuss it at your discretion. We're trying to set up non-jury trials. We've yet to have one, but I think you may have noticed that we have a very astute prosecutor, and he is not, to my understanding, greatly opposed to a non-jury trial. It's a matter of discussion and trying to work that out and basically get the approvals from higher up. So with that, any further question or comment from either state or defense?
not at this time, Judge, although if we do waive a jury trial and ask to proceed on a bench trial, I would like to do that on the record. If before we log off of this, maybe I could go into a breakout room with my client, discuss that for a few minutes, and come back.
All right.
So we could put it all on the record.
Very good.
Well, regardless, Your Honor, the state would need to agree to a bench trial in writing filed with the court.
Right.
Okay.
Okay. We'll wait. We'll give you about 10 more minutes, Mr. Freilich, to go into a, what do you call that, Patty?
Breakout room?
Breakout room, yeah. All right. I'll be sitting here waiting.
Thank you, Your Honor.
And Your Honor, I will remain here until you allow me to leave.
If you want to leave at this point, you may, or if you want to wait for Mr. Freilich to conclude his final comments, that's fine too. You tell me. It's you have my permission to leave if you choose, or you can wait a little while.
Well,
Yeah.
I think it would be advisable to remain until Freilich has conferred with his client and makes any more remarks of the court.
Very good. All
It
right.
shouldn't take too long. Thank you, guys.
Thank you, guys. And I think, well, you're gonna have to wait too, Kayleen. So
I set you up, Andrew. You can go to breakout room too.
Is this going to be one of those things where I don't see the link?
I did it for your client as well.
you're gonna put him in the corner, Patty?
Yes, sir.
All right.
Patty, I think you gave that invitation to the wrong Andrew,
No,
because I also received an invitation to
I
join
know,
breakout
sir.
room 1.
I just have to break it up like that. but they're gone. Well, he's trying to log on there.
Are they in breakout, Penny?
Mr. Green, you need to join breakout room 2.
I thought I accepted.
No, you haven't.
Is there any way you can send that again, ma'am?
It's there. It's just showing you not moved. Yay. Judge, can I shut down YouTube or not yet?
No, since he wants to put something on the record, let's wait a little while.
Okay.
I think that'd be the smarter thing to do in this case.
Okay.
All right, Mr. Edelman, I believe, do you have a form where we would agree to waive a jury or well, I guess the next question is, would you agree to waive a jury? But
Judge, do you want me to go on the record?
Yes, ma'am. Put this on the record. Thank you.
okay.
Mr. Fraley.
My client and I, after discussing the case, Your Honor, would be interested in waiving a jury and proceeding on a bench trial.
I would not agree to it right at this moment. I would want to confer with the complainant first and with my division chief and find if the district attorney's office has any opposition to a bench trial. And after that consultation, if the state is in agreement, then we'll file that agreement in writing.
And Mr. Fraley, you requested a copy of the order that is sufficient for the state. Andrew Edelman. I always want to refer to you as Andrew, but you're both Andrews. Mr. Edelman, do you have that form that you can share with them by scan or otherwise?
The state's consent to waive jury trial?
Yes, sir.
I don't know if I have it immediately available or not, but if I don't, then I will make sure to make one available.
Very good. As long as you're a gentleman. And Mr. Fralick, likewise, then I think that will conclude this hearing at this time. Anything further?
Nothing further.
Very good. Thank you, gentlemen. Mr. Green, take care. Good luck. All of you, be blessed, be well, and be safe, okay? And that'll conclude this hearing. Thank you.